the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on our expanded panel this morning is our newest Justice, Justice Paul Smyth. Just by way of introduction, I'll round out the rest of the panel. To my right and your left, to the far right, is Justice Suk-Young Shin, Justice Amy Blake, and Justice Eric Neyman. It is our great pleasure this morning to welcome our newest Justice, Paul H. Smyth, who was sworn in on December 5th by Governor Charlie Baker. By tradition, the Appeals Court employs an expanded panel of 5 judges for the first case heard by a newly appointed member of the court. For the remaining cases today, after the first case, a three-judge panel will sit, consisting of Justices Neyman, Shin, and Smyth. Justice Smyth graduated with a Bachelor of Arts from Amherst College and then earned his Juris Doctor from the University of Virginia Law School, where he was a Ritter Scholar for exemplifying extraordinary honor, character, and integrity. He was born in Springfield, Massachusetts, and raised in South Hadley. He now resides with his family in Ashfield. After his graduation from law school, Justice Smyth began his career in the Suffolk County District Attorney's Office, prosecuting a wide range of criminal cases in District and Superior Court, as well as training assistant district attorneys and Boston policy personnel on issues related to domestic violence investigations and prosecutions. He was part of the homicide response team and represented the office in several community outreach initiatives. He received an Outstanding Service Award for his work in 1999. From the District Attorney's Office, he went on to become an Assistant United States Attorney in the Springfield office. During his tenure at that office, Justice Smyth was a faculty member at the Department of Justice National Advocacy Center, served on the Civil Rights Enforcement Team, and eventually became chief of the Springfield branch office. He received numerous commendations for his work in victim witness service and contributions to organized crime and drug enforcement. In 2015, he was appointed as an Associate Justice of the Pittsfield District Court and elevated to First Justice in 2018. He's presided over the Berkshire County Drug Court since 2017. While on the District Court, he also served on that court's Racial and Ethnic Fairness Committee and its Education Committee, and on the Trial Court Race and Implicit Bias Advisory Committee. Here at the Appeals Court, we allow new judges to settle in for a year before assigning them to committee work, but I have a couple of ideas in mind for Justice Smyth once that period expires. Outside of the law, Justice Smyth spent 2 years as a Peace Corps volunteer in the Marshall Islands, where he taught in and developed curricula for elementary schools. He's also coached his children's sports teams and has participated yearly in the Pan Mass Cycling Challenge, raising money for the Dana-Farber Cancer Institute. Here at the Appeals Court, we follow the custom used in the Superior Court of numbering our judicial seats in the order they were created. Justice Smyth is occupying seat number 15, which was created as part of the first expansion of the court in 1978 and was previously held by Justices Joseph A. Grasso Jr. and C. Jeffrey Kinder, among others. And I would be remiss if I did not observe that his arrival, seat number 15 was created as part of the last expansion of the court in 2001 and was previously held only by Justice Joseph Grasso and C. Jeffrey Kinder. And I was about to say I would be remiss if I did not observe that his arrival reminds us all of another Justice Smyth from Western Massachusetts, whose portrait hangs on the back wall of this room, our dear late friend and colleague, Justice Kent B. Smyth. I should also note that, counting all statutory and recall justices, he is the 81st person to serve as a justice on this court. It is an honor and a privilege to welcome Justice Paul H. Smyth to the Massachusetts Appeals Court, and I invite you all now to rise with me to welcome our new colleague. And I will now ask the Clerk of the Appeals Court, Joseph Stanton, to read Justice Smith's commission.
To all to whom these presents shall come, greeting. Know ye that we, by our Governor, with the advice and consent of our council, confiding in the ability, discretion, and integrity of Paul Hart Smith of Ashfield, do hereby, under the provisions of Chapter 211A of the General Laws, as most recently amended, and in conformity with our Constitution, constitute and appoint him to be one of the Associate Justices of the Appeals Court, to hold said trust during his good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin him, he said, Paul Hart Smith, to execute and perform all the duties, and he is invested with all the powers and responsibilities which, by our Constitution and laws, do or may pertain to the said office, so long as he shall hold the same by virtue of these presents. Witness His Excellency Charles D. Baker, our Governor, and our great seal hereunto affixed at Boston this 5th day of December, in the year of our Lord 2022, and of the independence of the United States 246.
Well, again, welcome, Justice Smith. Now let's get down to work. We will allow just a bit of time for those who are present here simply for the ceremonial portion to exit the courtroom, and as they do, we will begin with the hearing list today with case number 2022 P-124, the Commonwealth versus Scott CARNEY.
Good morning. If it please the court, Joseph Hasson for Scott CARNEY, the appellant. This is a case that for me has a lot of moving parts, and one of the parts that I really had a lot of difficulty with was proving prejudice on the on my first first issue about the erroneous jury instructions on the different levels of intent required for the for each of the charges, coupled with what I believed was the prosecutor shifting the burden to the defense. In my mind, you needed both of those pieces to work in conjunction in order to prove prejudice. In any event, as I said in my brief, the judge told the jury that that the intoxication applies to all three of the crimes. In other words, assault and battery on a police officer, regular assault and battery, and simple assault based on an attempted battery. And we all know that that's not correct. It only applies to the specific intent crime of assault and battery on a police officer.
Was there an objection from defense counsel at trial?
They went to the sidebar, and the prosecutor said, you know, this doesn't apply.
Prosecutor objected. My understanding is
Right.
that defense counsel actually sought the instruction on intoxication as to all three counts.
Well, he wanted it well, I don't know, I mean, he knew there's, you know, at sidebar, he understood, and I put it in a footnote of my brief, that both parties and the court understood that it only applies to specific intent crimes, of which assault and battery on a police officer.
But did defense counsel ask for the instruction as to all three counts at trial?
I don't believe he did. If you're saying, my memory was that he didn't because he knew that, and most people know that assault and battery and simple assault based on an attempted battery are not specific intent crimes, and intoxication is inapplicable to those crimes. And so you have a situation where...
Could I just interrupt you, sir, for a
Yes.
moment? I think that's a misstatement of the law. I think assault is a specific intent crime. The Commonwealth cites as authority the Commonwealth v. Melton. That's one matter, or one case. It stands for the authority that an attempted battery is an intentional, specific intent crime.
Well, I know the case law says that regular assault and battery is not a specific intent crime, so
He
if
was
you,
convicted of assault, and that's what you're addressing today, correct? The assault?
based on an attempted battery, not on a threatened battery.
Correct.
Right. And my understanding, since that's a lesser included offense of regular assault and battery, which the case law says is a general intent crime, I don't see how a lesser included offense gets jacked up to being a specific
Not
intent.
jacked up, it's a matter of the distinction between assault and assault and battery. Assault by means of a threatened battery is still simply assault,
But this wasn't a threatened battery. This was an attempted battery.
attempted battery.
He was going to charge the jury on both, but he decided not to do that.
Do you have a case that says that assault is a general intent crime?
I believe that there was one in my brief, but off the top of my head,
I didn't see one.
well,
in
if
your
it's not there, then it's not there. But I mean, assault and battery,
No, but we're not talking about.
no, I
assault.
understand that.
We're
I
talking
understand
about assault accomplished by means of an attempted assault and battery. And I don't see any inherent reason why that would shift the nature of an assault, which is a specific intent crime.
Well, that being the case,
So before you get to prejudice,
right.
you
No,
need to establish error.
I can't establish prejudice if that's the case, because obviously,
You can't establish error, and therefore the
Right,
prejudice falls
right,
out, but
right.
we also have the exacerbating challenge, or you have the exacerbating challenge, that the defendant appears to have requested the instruction in any event.
right, on the effects of intoxication.
And he
Right.
was acquitted on the ABPO and the A and B.
Exactly. That's the sticky wicket for me.
All right, so then you've got your other argument.
My other argument is, he did object to a jury instruction on just simple assault based on an attempted battery. Now, looking at the evidence before the court, the person who was battered was Officer Worrell, and his testimony at trial was that contact was made with him. And so the only issue at trial was whether or not that contact was intentional, or whether it was negligent, accidental. And so the court said, you know, I'm going to give the instruction. And again, Worrell said, I was contacted, and I didn't see any evidence that would counter that. I believe the
Did he
second
first
police,
testify that he wasn't contacted?
but then on redirect, he said,
So there
they
was
asked,
a
were you
conflict.
contacted?
There
And he
was a
says,
conflict
yes.
in the evidence, which is for the jury to resolve.
Right, right, Jackson versus Virginia, right.
And defense counsel actually argued that the officer couldn't identify where he was hit. So doesn't that support the Commonwealth's argument?
Well, I mean, if you're hit, you're going to feel you're hit. And Officer Worrell said, was contact made? And he says, yes, contact was made with me. And the other officer, the second officer, says, I believe he was contacted, but he wasn't sure.
What if the jury chose to believe that the defendant was thrashing about and either attempting to strike someone or and missed, and didn't believe the officer's testimony that he was actually struck?
Well, I mean, the jury can believe what they want to believe, as long as it's not completely off the
So that
path.
That would support the instruction as given. Because there was evidence from which the jury could find the elements.
Well, yes, because the officer, again, my argument was that who would know better than Officer Worrell if Officer Worrell was, but I understand
For
that
the jury.
the jury could come up with, right, which is why I said at the beginning, this case had a lot of moving parts, and I didn't know if I was going to prove prejudice, but I'd give it the old,
Well, yeah.
The old
Again,
college
before you get
try.
to prejudice, you have to prove error, but.
right.
So then we've
Right.
got the closing argument?
Well, the closing argument, again, he said to the jury, you haven't heard any evidence that would suggest that this man was overly intoxicated. And there was an objection, and they went to sidebar, and the defense counsel did say that, he's coming dangerously close to shifting the burden. And the judge, well, obviously, I wouldn't be here if the judge said otherwise, but he says, I think that's okay. And so,
But the Commonwealth says that was better left unsaid, right? They acknowledge that, but they say there's no prejudice. So could you address the question of prejudice?
Well, yes, I mean, the jury would say, okay, if they thought the burden was shifted, then they'd say, well, we haven't heard anything from the defendant in terms of, he hasn't proved to us he was intoxicated to the level that would negate specific intent, and so we're going to find him guilty. But that's not his job, it's the prosecutor's job, so.
Could the argument be seen as asking the jurors to use their common sense?
Not, well, yeah, I don't see it that way. I mean, when he says you haven't heard any evidence, and then there was other things that he also said that I mentioned in my brief, which I felt was burden shifting, because he kept saying you didn't hear. Well, the only thing you hear from is a witness on the stand. That's what you hear from.
And what's your best case, closest fact pattern what's your closest case or fact pattern for this particular comment in the prosecutor's closing?
I guess I cited in my brief hiatus. It's in the brief, and I said slightly different fact pattern, but it's analogous. If there's no other questions, I'll take my seat.
Well, the statements
Yes.
made that were objected to were even more objectionable than you've summarized. I mean, the statement was you heard absolutely zero medical or expert testimony regarding these conditions, regarding how this affects the defendant in his daily life, nor do you have medical records or anything of that sort that would detail you anything. I'm reading
Right.
from the transcript.
Right.
He followed that by saying the only thing you have is defendant's self-serving statement. So would you
Right.
say that those statements go to the heart of the case or an important issue in the case?
Yes, because they were very strong. I think what he said was stronger than what was said in the hiatus case, and the hiatus case was overturned.
there
Yes,
was no
because he said
jury
expert witness. I'm sorry. He said expert witness. When he says that, I mean, clearly it's not the Commonwealth is going to call an expert witness to prove the guy was intoxicated. That's antithetical to their position. And so, by inference, you're saying he should have called an expert witness to tell this jury what the effects of alcohol and you know, how much alcohol you need. You know, different individuals need different levels of alcohol depending, you know, on their ability to, you know, to withstand the effects of alcohol. So, he's saying you didn't hear any evidence from an expert. Who else would you hear it from?
Because the statements follow a comment on mental health and depression. Are you inferring these statements also apply to the intoxication from the context of the closing argument?
Yes, because I mean that was part of his defense, that I was too intoxicated to realize what I was doing. And again, the position of the defense was that the question here is not whether he was touched or not so much as was a touching done intentionally and not accidentally. And so that being the case, intoxication comes in to negate specific intent. And then the prosecutor says, well, you didn't hear any evidence, you didn't hear an expert. Well, who would call an expert? Only a defendant would call an expert.
The comment about the expert only had to do with mental impairment,
Well,
not intoxication.
right, but still, I mean, a level of mental impairment
Okay,
that's
so
less
in the
than...
Coyotes case that you rely on, the defense theory was the defense counsel directly raised the argument that the victim was not credible because she was mentally ill. I don't see the defense theory here being that the defendant was incapable of forming intent because he was depressed, right? The theory was that he was reacting to a show of force from the officer. So how does the comment, if error, prejudice your client's case?
Well, again, as I said, you're telling the jury that, you know, if you look at the totality of what the prosecutor said, he's telling the jury that the burden is on him, on the defendant, to prove something that would negate specific intent, and he hasn't done that. And there are two things that can negate specific intent. One is being being intoxicated to the degree where you cannot form the specific intent, and one is a level of mental illness that doesn't rise to the level of diminished capacity. So, as I said, it's a close call, and I really you know, had a problem with it.
Right, anything further?
Nothing further.
Thank you.
Thank you.
From the Commonwealth?
Good morning, Your Honors. Excuse me, Stacey Gauthier for the Commonwealth. Oh, sure. I'm sorry. It's okay. There you go. Stacey Gauthier for the Commonwealth. It's the Commonwealth's position that the defendant's conviction should be affirmed here and that there was no error that would require reversal of his conviction. With regard to issue number 1, assault is a specific intent crime. That's Commonwealth versus Melton, which was cited in my brief. The elements of attempted battery, which is the type of assault that was instructed, are that the defendant intended to commit a battery, took some overt step toward doing so, and then came reasonably close to doing so. So I would suggest that is specific intent.
It's the intent to commit a battery that addresses your brother's comment earlier that where it's a lesser included of assault and battery, it's specific rather than general intent?
The assault would, even if it's a lesser included, the assault, I would suggest, would still be a specific intent. It's a specific intent crime. Assault and battery on a police officer, specific intent. Assault and battery, general intent. And it was the defendant's trial counsel who asked for the instructions, so I would suggest he can't now, turn around and allege prejudice. So I would just move on to issue number 2, the closing argument issue.
He objected to, before you move on, he objected.
Sorry.
Didn't he object to the assault? He
He
didn't
did.
object to lesser included assault and battery, but he objected to the offense of conviction, the assault, correct?
Yes, that's correct, Your Honor.
And can you tell us how that's a lesser included based on the evidence?
The assault?
How that instruction was warranted?
Because I'm getting the officers confused. They both were last name Morrow, but the officer who is listed as the victim in that case, he first testified on direct examination that the defendant did not kick him, but then later on in his testimony, he testified that during the flailing, the defendant's body made contact with his body. So I would suggest the jury could have found either that the defendant kicked Officer Worrell or that no contact was made. So I would suggest that that's where the lesser included would come in, if the jury found that there was no contact made.
And what is your position on the pointing, the testimony of the pointing finger in the face or the spitting or potential threat to spit? Would you say those amounted to an assault?
Sure, attempt to spit at someone, that could certainly be an assault.
Not a hypothetical. In the evidence in this case, the testimony was that he was gathering spit, they thought.
But he didn't, you're right, Your Honor. He didn't actually spit. I think it was just that he was making a noise, but I believe it came out on cross-examination that he didn't actually, attempt to spit. I think that the assault would have been when he was kicking at the officers, when they were trying to, handcuff him.
Very good, thank you.
Thank you, Your Honors. With regard to issue number 2, I would suggest that any errors that were made in the prosecutor's closing argument in the circumstances of this case did not prejudice the defendant.
Attorney Gauthier, I'm not shooting the messenger, but I can't tell you how many prosecutors stand where you are and say, it was better left unsaid. And I appreciate the argument that then the question is prejudice, but what's happening in terms of training young prosecutors? Because you shouldn't have to be in the position to say it was better left unsaid. It shouldn't have been said.
That is entirely correct, Your Honor. I would first say
Ask that message be delivered in some way.
Actually, Your Honor, just as a response to this case, we did send out an email from the appeals unit to the district court, ADAs, reminding them of what is appropriate to say and not to say in closing arguments. I would just say that the person who made this statement is no longer at the office, unfortunately, so they didn't.
No, but the new person, therefore, didn't get that memo.
Right.
So the broader question, I think, that you hear from Judge Blake is, on a systemic level, what can you do on a preemptive basis to ensure that this doesn't happen again, rather than responding to those occasions where it does?
We could certainly hold a training with the new assistant district attorneys to reiterate.
And when is that scheduled?
We have not scheduled that yet, Your Honor. That is something that we could do, but we did, in fact.
A good idea.
It
Well, they
would,
could also
yes.
watch these on Zoom and YouTube and see exactly what happens when they're not sitting next to you when we pick apart their closing arguments.
That is correct, Your Honor. Again, we did send out an email, and I would also, I know, for what it's worth, this was a district court assistant district attorney.
People come in all the time, and they're not going to have received the last email. And I think that it's incumbent on the office to ensure that that as part of the onboarding and training and orientation process, these attorneys are equipped to do their jobs appropriately.
I could certainly make that suggestion to my office. Thank you, Your Honor.
And show them this hearing on,
They are,
as Judge
So
Blake says.
let's
we
move
on
on
Zoom,
then.
they might be watching it now.
Let's move on to the question of prejudice, because I agree with you, prosecutor shouldn't have said it. You know, they were pushing the line here.
Yes, it was, you know, I'm not going to defend it. It was certainly unfortunate. What I would point out is there was only one statement that was actually objected to, so that would be the standard of review there is for prejudicial error. And then there were two statements that were claimed as error in the brief that were unobjected to, so those are at the higher standard, you know, substantial risk of a miscarriage of justice. But in the end, the defendant was only convicted of the second of two lesser included offenses. And so I would suggest under Commonwealth versus Grandison, which is cited in my brief, that case had stated,
Well, that's certainly some evidence that.
that's some evidence that there was no
But
prejudice.
as you say, the jury could have found that there was no battery.
Right.
That's correct.
So how much weight can we really put into the acquittals on the battery charges?
They could have found that there was no assault and battery.
They could have found that there was actually no contact made with the officer, which is your argument why the lesser included instruction was appropriate. So how much weight can we put into the acquittals on the more serious charges?
Well, I would suggest that for, with regard to the assault, if they found that,
I mean, it's always hard to speculate why a jury
What the
found
jury
what
did,
they did, right? So, but, you know, in this case, there was a distinguishing factor, as you point out, between the lesser included and the more serious charges.
so I would suggest that the prejudice, certainly that, again, I can't, you know, I'm sorry, I can't speculate on what the jury did. They could have found that, like, split the baby, so, you know, so to speak.
This particular misstatement was not objected to, if I recall correctly?
The statement that was objected to was the statement that said you heard zero medical or expert testimony regarding these conditions.
Burden shifting was preserved, and so we're testing for prejudicial error.
That is correct, Your Honor. I would look at also, just going back to Justice Shin's question that I was unable to answer a second ago, I would point out that the instructions that the judge gave also would have mitigated any prejudice, because the judge did say, you know, the closings are not evidence. He stated that the evidence consists of the testimony of the witnesses before you and any evidence that was submitted. He
As
also...
practice would be at the time the error was made, correct? And there was no instruction immediately?
That's correct. Actually, the defense attorney asked for an instruction, and the judge refused to give a curative instruction. But he did correctly instruct on, you know, the Commonwealth's burden, as well as the presumption of innocence, and it's presumed that the jury follows the judge's instructions, although they were not, you know, specific to that specific objection. But I think that the general instruction that the testimony of witnesses is evidence, I think that would have been enough for the jury to weed out the defendant's, the prosecutor's hyperbole that, you know, there was no evidence, when clearly we know that the police are there for a suicide attempt, and we know that they were concerned enough that they wanted to take him to the hospital, and we also know that eventually, after they were able to get him handcuffed, he was taken to the hospital for what's called a, quote, Section 12, which is a mental health hold. If there's no further questions, I would rest on my brief for any unaddressed issues.
Seeing none, thank you both. That concludes the argument in this case. We will take a very brief recess for a change in the panel, and the remaining 4 cases in court will resume with a conventional panel of 3 justices.
Thank you, Your Honors.
All rise, please.